There we go. Okay. It sounds so ominous. All right. Thanks. Take it away, Angela.
Hi, everyone. Okay, so let me first share my screen with you all. So the presentation is here. All right, so can you all see the presentation? Okay, so my name's Angela. I'm an attorney with the Workers' Rights Program at Centro Legal de la Raza. Centro Legal, we're located in Oakland by the Fruitvale Plaza. We have different areas of law that we practice. We have the Workers' Rights Program. We also have immigration. We have tenants' rights that help tenants in the East Bay. We also have a youth law academy that helps high school students from Oakland get into college and into law school. And together, we all work together to really try to empower the community. So what I'll be covering today is a general workers' rights overview, which will encompass like minimum wage, right to meal and rest breaks, a little bit of discrimination, a little bit of retaliation, as well as our contact info should anyone need our services, because all workers have rights in California. There's a lot of protections in the state of California, and then localities such as San Francisco and Oakland also have additional protections. So to start off with, I just want to give a brief overview of the laws that apply. As I said, so we have the state laws, which are one of the most protective ones in the country. Or I do want to say they're the most protective ones out of the whole country. And state laws really govern minimum wage, paid sick leave, retaliation, and discrimination. And what I just talked about, there's the local ordinances, specifically in the Bay Area. Cities like San Francisco and Oakland have even more protections. So higher minimum wages, more rights to paid sick leave law. And then we have federal laws, which are kind of the baseline of the minimum that employers have to do. But with all this said, given that there's like 3 layers of possible laws, especially if you're working in the Bay Area, we always go with the most protective law. So we're going to go, let's say if you work in San Francisco and the minimum wage is significantly higher than the state minimum wage, we're always going to go with what the local ordinance says. So let's start off with who is covered under employment law in California. So you must be an employee. You cannot be an independent contractor. And now I know this has been kind of controversial in recent years because of misclassification in gig workers, Uber and Lyft drivers. So the reason workers' rights advocates like ourselves really advocate for people to be properly classified as employees is because if you're not classified as an employee, you get none of these protections, nothing. You are basically out of luck for anything. So with all that said, just because an employer tells you you are classified as an independent contractor does not mean you are an independent contractor. To be classified as an independent contractor, you must meet what's called the ABC test, and the employer has the burden of proving that they meet all these tests. So to be properly classified as an independent contractor, the employer must show that you as a worker are free from the control and direction of the higher entity. So they cannot be calling you, telling you what to do, telling you must follow these specific policies, telling you, right, just telling you everything to do and then still telling you, no, you're an independent contractor. You must have control and direction of what you're doing. A true independent contractor decides what they're doing. They're just on a contract for a specific project, right? They're not being governed by this entity. Second, in addition to number 1, the employer also has to prove that the worker is performing work outside the usual course of the hiring entity's business. What this means is, like, for instance, we see sometimes independent contractors like in beauty salons, right? Like there's one big owner that only does hair cutting businesses. They hire another person that does hair cutting businesses. So that's still the same usual course of business, right? So that it wouldn't necessarily meet this element. However, a true independent contractor, for instance, can be like a cleaning person that has their own business and goes to like a homeowner's house, and they go to different businesses all the time, right? It's not just, you're not just doing the same work that you're being contracted for, but you're doing work outside of the hiring entity business. It gets a little complicated, so we always encourage people to give us a call to see if they're properly classified. So in addition to performing work outside the usual course of business, the employer must also show that the worker is engaged in an independently established trade, occupation, or business, not as the same nature of the work performed. So this kind of goes with number 2, right? So you can't be saying that your worker is an independent contractor, again, if they're doing the same type of work that you already do. Some like true independent contractors sometimes are like taxi drivers that drive on their own behalf and have their own company, not relying on applications like Uber and Lyft that control and direct everything you do. So yeah, just because you're classified as an independent contractor does not mean you're an independent contractor. And by being classified as an independent contractor, you don't get any of these protections. It's really important that the employer correctly classifies someone as a worker or an employee and not as an independent contractor. Another scenario that we usually see are that exempt salary workers. So there's a difference between exempt and non-exempt. Exempt salaried workers means that you are exempt from certain labor rights such as overtime, meal and rest, but if you are non-exempt, that means you are eligible for all the overtime laws and the different things that I will cover today. But again, employers like to put on these titles of you are a salaried exempt employee. And just because they give you this title does not necessarily mean you are one. They must meet a test. First, you must make 2 times the state minimum wage. And you also must have some form of discretion. Like you get to decide what you're doing and not having orders from a higher up telling you have to do this at this time, this at that time. So again, if you have any questions, feel free to give us a call. Our phone number I'm going to share at the very end. And like I said earlier, employers are going to try to look for ways around California employment laws by misclassifying workers. So keep an eye out for that. So as I mentioned earlier, what I'm going to cover today is a little bit about minimum wage, overtime, double time, meal and rest, paid sick leave, final pay, employment records, and a little bit of discrimination and retaliation, and how to file wage and hour claims with the Department of Labor Standards Enforcement, which is the Labor Commissioner's Office, who is the agency in California that enforces all of these laws. So minimum wage. All workers are entitled to the minimum wage for all hours worked, and this cannot be waived. So you cannot sign a contract signing away your right to minimum wage. Even if you do sign a contract signing away your right to minimum wage, it's not enforceable. It's against public policy. So keep an eye out for that. And as I mentioned, if you work in the Bay Area, keep an eye out for what the minimum wage is. So for instance, in California, the state in general, if you're not covered by a local ordinance, the minimum wage, if there's 26 or more employees, is $14 an hour. If there's 25 or less employees, it's $13 per hour. If you work in San Francisco, as of July 1st of this year, it's $16.32 an hour. If you work in Oakland, it's $14.36 per hour. So keep an eye out on where you're doing your work because again, it all depends on the locality and the most protective law is going to apply. So what happens if your employer doesn't pay you minimum wage? Unfortunately, we actually see this a lot at Centro. So someone will pay someone $10 an hour, and just because a worker is like really needs the job, they'll take it. But that's against the law, and there's really big penalties that apply if an employer is breaking this law. The remedy is called liquidated damages. So not only do you get the unpaid minimum wages that you're owed, so the difference, let's say between $10 and the 16 and whatever cents, $16.32 that I said, if you work in San Francisco, it'd be the difference between 10 and that, right? So that's the difference. And then on top of that, you also get an additional difference of liquidated damages of every hour you're owed equal to the minimum wage. So it kind of doubles what you're owed because it's a big penalty. The government does not want employers breaking this bare minimum right that workers have. So let's talk a little about overtime and double time. And please, Olga, I know you're, I see you're one of our participants here. So if you have any questions, please feel free to just raise your hand or just shout it out. I'm more than comfortable answering during the presentation. So overtime and double time. So overtime applies, there's both daily and weekly overtime. Overtime is 1.5 times your regular rate of pay. So let's say I'm going to make it really simple. So I'm not going to be basing it off of minimum wage because that would break the law. So let's say minimum wage was $10 an hour, right? Time and a half overtime would be 1.5 of that. So it would be $15, right? Because half of 10 is 5. So 10 plus 5 is 15. And that's your overtime rate. But you would apply that to whatever your hourly rate is. And this would apply any time over 8 hours and any time over 40 regular hours in 1 week. And then on the 7th day, if you work Monday through Sunday and you work all of those hours straight on your 8th day, the first 8 hours are going to be considered overtime and have to be paid 1.5 your regular rate of pay. Double time. So double time would be 2 times your regular rate of pay. And let's go back to the example. That is not the minimum wage, $10. So double $10 is 20. So for every 12 hours you work in a day, after 12 hours, you get double time. So in this scenario, you would get $20 an hour. And then again, let's go back to our 7th consecutive day. You're working Monday through Sunday. You worked all those days, then you get to Sunday. Remember, the first 7 hours are going to be overtime, time and a half. But after you work 8 hours, double time kicks in. So it's very important to keep an eye out for that because some people forget a lot of the 7th consecutive day and also that there's both daily and weekly overtime. And as I mentioned earlier, fixed salaries almost always violate overtime rules if you are not properly classified. So please keep an eye out for that. And here is a really good visual. So this is a work week, right? So we have a sample work week, 14-hour days. This worker works from 9 a.m. to 11 p.m., 7 days a week. So let's say Sunday from 9 to 9. I think this visual is a little bit incorrect, but let's say they work from 9 to 5, right? That would be 8 hours and they don't get a lunch. So let me actually switch visual. Sorry, I apologize for that. So let's actually go back to this because I think it reorganized the visuals, but let me just so I'm just gonna give you the sample work week. So it's a 14-hour day, 9 to 11 p.m., 7 days per week, no lunch break, very important, which I'm gonna cover. So if the person starts at 9, you would count 8 hours, right? 9, 10, 11, 12, 1, 2, 3, 4, 5 p.m., right? So those from 9 to 5, they would get their regular hours. Anytime after 5 p.m., between 5 to whenever the 10-hour mark would hit, which would be around 7, right? That would all be the overtime. I'm sorry, I'm like getting really muddled up because of these visuals. But let's just go back, right? First 8 hours regular time, between the 9 to 12-hour mark is going to be overtime. Anytime after 12 hours, it's going to be double time. And because there's no lunch break, additional penalties apply. So I do have to give you guys better visuals on these because they're actually really handy, but not today, for example. But let's talk about meal and rest breaks since we just talked about that a little bit. And please let me know if you have any questions in regards to the overtime and double time because it can get really confusing. So for meal and rest breaks, so you're entitled to a 10-minute rest breaks on the clock, means paid, for every 4 hours that you worked. So let's say you work from 9 to 5, that's 8 hours. So that would mean you get 2 10-minute rest breaks. And again, these are not waivable, meaning you cannot write down that you're waiving your rest breaks. And very important, this does not include bathroom breaks. So if you have to use the bathroom, you don't necessarily have to use your 10-minute break to use the bathroom. In addition to this 10-minute rest breaks, you also have your 30-minute meal break, which is off the clock, meaning it's not paid time off. And this applies every 5 hours that you work. Very important for your meal break is that you have to be completely relieved of all of your duties that you're working for. So let's say you work at a restaurant, right? And you say it's your 30-minute lunch break. And you sit down for the first 5 minutes, you open up your lunch, right? And then all of a sudden your employer comes and tells you, hey, can you actually there's a new customer, can you go sit them down, right? That is an interrupted lunch break, and that does not count. Or for instance, another thing that we commonly see is, let's say you work in an office and you work hourly, like eating at your office while you're checking emails is an interrupted lunch and doesn't count for your 30-minute meal break. You have to be completely relieved of all of this. So what does this mean? What this means is that please take your breaks. I know a lot of people say, I don't want to take my break because I just want to work completely through it. No, you have these protections and you have these rights, and you should really assert these rights that you have. And what happens if you don't get it? There's a penalty that applies to your employer that you can recover when you do a wage claim in the labor commissioner. So for each 10-minute rest breaks that you are entitled to for every 4 hours and your 30-minute lunch break that you're entitled to every 5 hours, you can get 1 hour of pay at a regular rate for each meal and rest break that you miss. But you're capped at 1. So 1 hour of pay. So for instance, if you didn't get your 2 10-minute breaks in one day, you can only claim 1. And this is actually a good chart that that wasn't disorganized. So here's a really good chart that shows when you are entitled to a 10-minute and 30-minute rest breaks, and when you can lawfully waive your meal break. Remember, not your rest break, but only your meal break. So if you work less than 3.5 hours, you're not entitled to any 10-minute or 30-minute break. If you work between 3.5 hours and 5 hours, you're entitled to 1 10-minute break because you worked more than 4 hours. Between 5 to 6 hours, 1 rest break. You could get 1 meal break, but technically, if you work 6 hours, you can waive your meal break lawfully under the law, but technically this is when your employer gives you something to sign off of if you only work 6 hours. And so the chart goes on kind of telling you how many each applies. Remember, 10-minute after every 4 hours, 30-minute lunch break after every 5 hours. So let's get into paid sick leave. So again, we're going into the different layers of law. We have the local ordinances, the state, and the federal. Here, we're only going to be focusing on the state and the local ordinances. So in California, generally, every employee is entitled to a minimum of 3 paid sick days per year. If you live in the Bay Area, you're entitled to more. So for instance, in San Francisco, if your employer has more than 10 employees, they can give you they should be giving you 72 hours of paid sick leave, and if they have less than 10 employees, it's 40 hours. And with all of that, your employer can either provide you the 3 days of sick leave up front or use an accrual method, right? Of, for instance, 1 hour of paid sick leave for every 30 hours that you've worked. And generally, most employers don't allow you to take the paid sick leave until after 90 days. So you can be accruing your paid sick leave, but not actually be able to take them until after 90 days. And also very important is that you can use the sick leave for yourself or a close family member. So for instance, if your child is sick, you need to stay home, you can use your paid sick time. And make sure that the accrued, available, and used sick leave hours show up on your pay stub. So when you receive a pay stub, there should be a section that says how much paid sick time you have. Sometimes it's included in a PTO policy, but you should be seeing how much accrued paid sick time you have. If it doesn't show on your pay stub, your employer can be liable for $4,000 penalty that a worker can recover. So that goes with the remedies, right? So if you don't get any paid sick time, you can seek the pay for the sick leave hours that you use. So for instance, you took one full day, 8 hours, right? You requested it from your employer. You asked them, hey, I have a doctor's appointment. I'm not feeling good. I'm going to be out today, right? You requested it from your employer. Then you get your next paycheck and you see you actually weren't paid for that day at all. They never paid you that paid sick time. So what would happen is that you would be able to recover that whole 8 hours. And then you can also seek treble damages, which just basically means triple that 8 hours and then an additional $4,000 if it doesn't show on your pay stub. So these penalties add up again because the government does not want employers breaking these minimum like laws that are there to protect all workers. Something very important, we get a lot of clients coming to our office and they're like, my employer hasn't given me any vacation time or they haven't given me any holidays off. Unfortunately, in California, there's no right to vacation time. So that's not something that's a right. It's more a privilege. But if your employer decides to establish a policy or practice, for instance, they have a contract, they have a policy that every employee gets 3 days vacation, right? You can enforce that, but that would be through contract law, not through the labor laws of California. And if you do have unused vacation time, when you end your employment with this employer, you must be paid out all your vacation time because these are considered wages. So very important on your last day of work, if you have any unused vacation time, make sure they are paying it all out. And going with final pay, so on your last day of work, you are entitled to receive all the wages that you're owed, but there's going to be a difference between if you quit on the spot versus quit and give notice and versus when you're terminated and when you should be paid. So again, employees must receive all of their wages on their last day of work, including unused vacation time. Now, if an employee quits without notice, so you just quit on the spot because you're just tired of your job, your employer is going to give you your wages within 72 hours, or they have the right to give you your wages within 72 hours, not on the spot. If you quit and give notice, they should be giving it to you on your last day of work. If they terminate you, they should be giving it to you on your last day of work. So that's very differences. So again, if you're quitting, it's a good practice to give notice just to make sure you're paid more promptly and also to keep a relationship just for future references. And if the employer fails to pay the full wages, again, it includes overtime, any unreimbursed business expenses, any unpaid vacation time, the employer is subject to waiting time penalties. What this means is that you can claim 1 day's worth of pay for every day that you're waiting for your full payment of wages, but this is capped at 30 days. So what we most often do is that employers never pay out all the overtime that an employee is owed on their last day because it's unfortunately we see a lot of wage theft cases. So then we can claim 1 day of pay for 30 days at the Labor Commissioner's office. Another important scenario to look out for is reporting time pay on the last day of work. So reporting time pay applies, let's say you show up to work at your required time, but then you're told to go home or there's no work. Under reporting time pay, you either have to be paid half of your day's worth of work or 4 hours worth of work. So that's really important to note because really it's wasting your time if you show up at your place of work and then they tell you go home, you already made the commute, you're already there. So something to look out for is reporting time pay on your last day of work. So now I went over through all the brief rights that employees have. There's so many more and I can go into a lot of depth into all of them. But let's say you come into Centro's office and you say, I wasn't paid my overtime, right? Or for instance, they never paid me time and a half for working more than 8 hours. They just paid me minimum wage all throughout. And we'll be like, well, you're entitled to time and a half for any hour that you worked after 8 hours. And then we can do a wage claim. But before we can help you do a wage claim, we always tell workers that you have the right to receive your timekeeping records and your personnel records. And your employer has the obligation to keep track of all these records and of your hours worked. So the first step that we encourage workers to do and that we help workers do is do a records request. And an employer basically has 21 days from the date that they receive this record request to provide these records, these time cards and these personnel records, so that we can do an adequate calculation. And also, if you end up going into the labor commissioner's process for a hearing, you're going to have to prove your case with evidence. And sometimes we don't have any evidence, but that doesn't mean your case is lost. It's good enough to show, right, that you did your due diligence requesting your records and your employer never gave it to you. So we can base your claim based on your best testimony. And again, there's remedies for this. So if they don't give you your records or don't give it to you within the allotted time, you can recover a $1,500 penalty at the labor commissioner's process, at the labor commissioner's office. So let's talk about the labor commissioner's office. So it's an administrative process. What this means is that it's not like normal court. You're not going to the state civil court. This is an office governed by the state of California. Again, it's the Department of Labor Standards Enforcement, which is housed under the Department of Industrial Relations. And under the Department of Labor Standards Enforcement, they have the Labor Commissioner's Office. And you do not need a lawyer to represent you at these wage claims. You can do it by yourself, or you can have a non-attorney advocate represent you. So for instance, when I was a law student or before I went to law school, I was doing these type of cases as a non-lawyer. So again, you don't need a lawyer to do this, but there are lawyers to help you out with this. So first you would file a wage claim with the Labor Commissioner's Office. You can find the form online. It's called, you just go to dlsc.gov, I believe, and there's forms on there. And it's just like check the box, fill in the blank, and then it'll ask you how many hours that you work, what are you owed, right? And if you come to our office, we help do all the calculations on an Excel spreadsheet. It's a little bit more technical, especially if it's very complicated calculations. It can take some time. And especially if you have a lot of records that we have to go through and you do receive your personnel records, you have to go through all your time records and calculate them all. A very important note is that you can only claim back 3 years worth of wages. So let's say you work 10 years and for all those 10 years, then they never properly paid you your overtime, right? Or they never properly paid you at all. Unfortunately, you can't seek the rights to all those 10 years. You can only go back 3 years. So that's why when you see an issue, a wage theft issue going on, you should try to do something about it as quickly as possible so that you don't lose any time on your statute of limitation. So after you file your wage claim, the labor commissioner is going to send you a notice for a settlement conference. Right now, everything is virtual. It's either over the phone or via Zoom. And a settlement conference is just a chance for you and the employer to really negotiate something so that you don't have to go all the way to hearing. You can be really successful in these settlements. And the good thing about reaching a settlement is that you'll see the money right away. Because with anything relating to hearings and cases, just because you receive a judgment or an order doesn't mean you're going to see the money. Because employers do a lot to try to hide assets or try to do things, and then you have to go through collections issues and try to collect on their behalf. There's pros and cons of settling, right? The pro is that you're going to see the money really fast and you're for sure going to see the money. The con is that you're not going to get all the money that you're seeking or claiming because you're negotiating. So you have to meet somewhere in the middle. but we've seen really successful cases through settlements. So let's say you can't reach a settlement, then the next step is a hearing. And this is where you really have to prove your case. And here, right, you have the chance to introduce your evidence. You can bring witnesses. You can do cross-examination. You can do direct examination. Then the hearing officer is going to provide you with an order or award. You're either going to win or not win or partially win. Let's say you don't agree with this, any party can appeal. They have like 10 to 15 days to appeal, and this goes to civil court. And this process is going to start all over again. So let's say you did win some money from the hearing officer from going to the wage claim. You can enter the collections process, and the labor commissioner has their own department that can help with collections. So that's the wage claim, wage theft, just wage and hour, you know, your right to overtime, double time, paid sick time, and lunch and rest breaks. So now let's talk a little bit about retaliation laws. So retaliation means that an employer cannot take adverse action for a worker standing up for a protected activity. Those two things are important and necessary to bring a retaliation claim. Because sometimes in everyday language, we use the word retaliation and discrimination without it having the same legal definition that the law requires for a case. So an employer may not take an adverse action against an employee for engaging in protected activity. Adverse action, again, we have to meet both adverse action and protected activity. And adverse action includes like they reduce your hours, they demote you, they terminate you, they make an immigration related threat. And they must have done this adverse action because of protected activity, right? And a protected activity, for instance, is that you're asking for your meal and rest period, you're requesting your payroll records, you're requesting your sick leave, you're complaining about health and safety, you filed a wage claim, you filed a discrimination claim, and because of that, they did those actions. That is unlawful. Your employer cannot do that. It's against the law. And if your employer does do that, you have 1 year to file a claim after the retaliatory action. The 1 year period can go by really fast, and it's a lot quicker period than the wage claim period, which is 3 years. So again, the minute something happens, you should really start acting so you don't lose your right to bring these claims forward. And in the retaliation process, you will be asked for evidence. Again, you'll be asked for some witnesses or any documentation that you have. So if you feel like there's retaliation going on in the workplace, start taking notes, start talking, bring a coworker with you to have a conversation if you feel like your employer is going to be taking retaliatory action with you. And again, these retaliatory actions can be filed with the Labor Commissioner's Office as well. And now discrimination. Again, we use the discrimination word so much in everyday language. So discrimination, the legal sense, is very specific. Your employer must have treated you differently because of a protected category. What we see a lot at Centro is that clients call us and they feel like they're being discriminated against because their employer is just a bad person. Unfortunately, the labor codes and the laws don't protect against bad people, like just bad people in general, or just like jerky people or people that aren't nice. They don't, what they always said is that the law doesn't protect, is not a civilities code. So it's not protecting against mean people, but they are protecting against protected categories. So California's Fair Employment and Housing Act, which is kind of the civil rights law in California, which is the equivalent to the federal Title VII, which is the federal civil rights laws, protects individuals from illegal discrimination by employers based on an employee's actual or perceived category of one of the things that I'm going to mention below. So let's talk about actual or perceived before I get into the different categories. Actual is they're treating you differently because of your actual race, right? Or your actual gender. but it's also unlawful for them to discriminate you because of your perceived race, your perceived gender. So let's say I'm not actually Latina, right? I'm like a white woman, right? But instead, they think I'm a Latina woman, but because they think I'm a Latina woman, but I'm not actually, it's still illegal to discriminate against me, right? So the protected categories here are race, ancestry, national origin, and this includes language discrimination, religion, age, but only over 40. So it only protects people being discriminated who are older than 40 years old. Disability includes mental and physical disability, sex and gender, which includes pregnancy, childbirth, breastfeeding, or related medical conditions. And sexual harassment is actually a form of sex discrimination. So sexual harassment is a form of sex discrimination. It's protected under FIHA. Sexual orientation, gender identity, gender expression, medical condition, genetic information, marital status, and military and veteran status. So your employer cannot be treating you differently or like be giving you harder work assignments or paying you less because of any of these protected categories, or you're not getting a job because of these discriminatory reasons or these protected categories, I mean. And these discrimination claims are also filed with administrative agencies, and they must be filed with an administrative agency before you can even go to state court. Whereas when I was talking about the labor commissioner's process, it's not required to go to the labor commissioner's office before you go to state court. But for these cases, you must do what's called exhaustion of administrative remedies, meaning that you showed that you went through the administrative avenues. So you can file these claims if with the Federal Equal Employment Opportunity Commissioner or EEOC, or the state version, which we normally do more often, which is the California Department of Fair Employment and Housing, or the DFEH. The statute of limitations for these are short. The federal claim with the EEOC must be filed within 300 days of the last discriminatory act. In California, it must be within 3 years. That's actually a newer law, which started in 2020. So that's, it used to be 1 year. So in California, you have a little bit more time. So that's actually all I have for today. Please feel free to ask any questions. I know that's a lot of information, but if you ever want to do a free legal consultation, we have free legal clinics at Centro Legal de la Raza. We're doing all our clinics over the phone, so you don't have to drive anywhere. You can reach us at 510-437-1554. Yeah. So yeah, any questions?
I have a question. So how does like it work, or like what does a employer gain from like paying their employee as an independent contractor versus as just an employee? Like, is it like less taxes for them, or
Yeah.
okay.
So they don't pay any taxes. So they don't pay any payroll taxes, right? So if you're classified as an independent contractor, instead of getting a W-2, instead of like you as a worker, let's say you're an independent contractor, instead of getting a W-2 at the end of the year, which you normally get as an employee, that you can, when you go and file your taxes, right, you show that you already paid all these like payroll taxes and everything. If you're classified as an independent contractor, you get a 1099. And there it shows that you didn't pay any taxes. So then you're going to be, as a worker, you're going to be owing a lot of taxes. And as an employer, they don't have to pay any payroll taxes because they don't have employees. They have independent contractors. And they also don't have to pay, well, right now under the pandemic. So before the pandemic, they didn't have to pay anything into unemployment insurance. Independent contractors weren't entitled to unemployment insurance. Right now they are, so that's very important to note. But before they weren't. They also don't have to pay anything for workers' compensation. They don't have to pay any workers' compensation insurance. They don't have to pay any overtime. They don't have to pay any double time. They don't have to pay any lunch and meal rest premiums. They can just basically say this person's an independent contractor. They can do what they want, but I'm still treating them as an employee without me having to, without me having to go through all the legal processes of actually classifying them correctly. So the employer gains a lot and the employee loses everything, all the protections.
Mm-hmm.
With all that said, it's not bad to be an independent contractor. It's just the employer must properly classify you as such and treat you as such.
Right. Okay. Awesome. And then Urga, I see you said thank you all. Did you have any questions or anything before you hop off? No? Okay. Well, thank you so much for coming. Appreciate it. Awesome. Well, I guess if there's no more questions, I think we can wrap up this first meeting and then give you a 10-minute break that you that you deserve as a worker. So yeah, thank you so much for the presentation. It was really, really informative.
Yeah, thank you.
Yeah, thank you. So
My
then,
pleasure.
great. So we'll hop back on the same link in 10 minutes and then we can get started, or full 8 minutes, and we can get started with the next presentation.
That works. Thank you.
Okay, thank you.